All right, we are live on YouTube and I'm going to let everybody in. Good evening, everyone. This is the Montgomery County Renters Alliance Renter Town Hall. We're just getting started, just letting everybody in the door. We are live on YouTube and welcome to everybody. If you're just joining us, we're just letting everybody in the Zoom doors. It takes a few minutes. Thank you for joining us. This is the Renters Alliance Renter Town Hall. If you're just joining us, we're just allowing people in the door on Zoom. It takes a couple of minutes, but we will get started in just a couple of minutes. We will start in just a moment, folks. Thanks for joining us. One more minute. It's a long minute, I know. All right, there it is. Okay, and that's exactly what I wanted, was one more person or one more minute, and that's what we got, both. All right, good evening, everybody. My name is Matt Losak. I'm a co-founder and executive director of the Montgomery County Renters Alliance. This is our Renter Town Hall. We have them twice a month, and this is the second one for July. For those of you who don't know us, we are the first and only regional nonprofit dedicated exclusively to renter outreach, education, organizing, and advocacy. We work closely with Montgomery County and other state agencies and as well as county agencies. We are here to help renters get their rights enforced and to get resources that they need for affordable, stable, quality rental homes. Tonight, we're going to talk about a couple of pieces of important news, but first let me introduce our panel. On my staff, we have David Mullins, Pat Beckham, and Malek Demir, who work vigorously to get information out to you door to door. And we also have with us the manager of the Office of Landlord and Tenant Affairs in the Department of Housing and Community Affairs, Nicole Catravanos. Welcome, Nicole.
Thank you.
So a couple of things. We are extremely disappointed and concerned that the council decided not to act on Bill 2222. This bill was proposed by County Executive Mark Elrich and would have, had it been acted upon and passed, limited rent increases to 4.4% after the May 15th expiration of the previous rent cap bill, emergency rent cap bill. Unfortunately, because the council did not act, rent increases that have been given to you in renewals since May 15th are going to remain in effect. And for those of you who have rent increases that are excessive, whether they be 5% or 50% or higher, we ask you to please let us know about those rent increases and to file a complaint with the Office of Landlord and Tenant Affairs. The only way that we're going to be able to have any hope to do anything to help you and perhaps pass this legislation in September for others who are going to be affected will be to have as many examples as possible, and also perhaps to give the Office of Landlord and Tenant Affairs the opportunity to evaluate each case and see whether or not there is some negotiation or any kind of conciliation that can be done with the landlord to bring down these astronomical skyrocketing rents. Nicole, do you want to add anything on that?
I just want to reiterate, what you said, Matt, to really please, we're encouraging all tenants to contact us, ideally via email when it comes to rent increase notices, and to attach your rent increase notice to the email. I'm sure it'll show up on the chat, but our email is olta.intake@montgomerycountymd.gov. And what we can do is we can review the notice, especially knowing now that the rent cap bill is not passing. It's very important to make sure that your notice is not deficient, because if it is deficient, and we can identify that's deficient, at a minimum, it can buy you another 3 months, because we can inform the landlord of the deficient notice and we can require them to reissue a new one. So it could buy you some time to be able to figure out your situation at home.
That is a huge point. And because I like repeating good points, let me say that again. When Nicole, who's a lawyer, says deficient, she means that it does not contain certain elements that are required by law. The county has specific elements that in a renewal notice have to be included. That includes your current rent, the increase, the percentage of the increase, the county's voluntary rent increase guidelines, which are now at 0.4%. It has to offer a 2-year lease unless you're on an annual financial recertification program. And it has to indicate that if you find this information or this increase excessive, how to contact the Office of Landlord and Tenant Affairs. Those elements must be included in your renewal. And if they are not, as Nicole points out, that is a defective or deficient renewal notice. It doesn't count. So they have to reissue it. And all renewal notices must be 90 days prospective, 3 months prospective. So if you've gotten one of these excessive rent increases and it happens to be on a renewal notice that is defective or illegal, you might be able to go back to go and start all over again. And if you find that out in September, when the council returns and maybe has a different frame of mind and has decided to look at rent stabilization, maybe there might be a chance that all of your rent increase might have to go back down to 4.4% as recommended by the county council. We don't know. I don't want to raise expectations. We are very concerned and disappointed about what took place. We believe that there are going to be thousands of renters who are experiencing excessive rent gouging by some irresponsible landlords, and that it's going to cost them their home. So I don't know what good news to tell you about that, except that the council will return in September, and there may be another opportunity to address this. And in order to us to address it effectively, we need to know who is getting these excessive rent increases. We've had at least 70 reported to the Office of Landlord and Tenant Affairs. Is that correct, Nicole?
We're about 68.
68, all right, reported. We've seen some at the Renters Alliance, some of our allies at the Latin Economic Development Corporation or Housing Investment Partnership, and other allies have seen also these increases, and we will try to be bringing them over to the Office of Landlord and Tenant Affairs. So that is a deep concern of ours. So
and
with
just
that,
a reminder that rent can only be increased once in a 12-month period. So I think most landlords are aware of that, but for some reason, if your rent has been increased more than once in a 12-month period, that's unlawful and that should be brought to our attention.
Okay, so if you have any questions or concerns, please put them in the chat. Our staff and I will be monitoring through them throughout the discussion. We're going to pretty much talk about two things tonight. These rent increases, your issues as renters, whatever they are, we'll try to address them as much as possible. And Ms. Katravanos will get to also the latest phase of the COVID rent relief program in her discussion. So I'll turn it over now to Nicole Katravanos at the Office of Landlord and Tenant Affairs. Nicole.
Thank you, Matt. Thank you, everybody, for being here. Just to kind of review a little bit as far as what the Office of Landlord Tenant Affairs has seen with reports on rent increases. As we have mentioned, we've received a total of about 68 reports. It would be very, very helpful for tenants to continue informing us of any rent increases so we can include that in our data points. The average of rent increases that have been reported to our office is about 22%. There have been a few outlier numbers that are higher than that, and usually those relate to month tenancies. So the average is about 22% for annual rent increase renewals, which is still significantly high. And as far as the services that the Department of Housing can provide, my office, which is the Office of Landlord Tenant Affairs, we are in a position where we can review your notices, your rent increase notices, to see if they are deficient, if they don't have everything that's required. If you submit it to us, the sooner the better, ideally via email, or you can mail it in to us. And if we see that it doesn't have all the legal requirements, we can then mandate the landlords to reissue the notice and provide you at least another 90 days for move out. And as you all know, that even if you have if those 90 days expire, you're not obligated by law to leave the premises. The landlord would then have to file something in district court, a failure to pay rent typically, and you'd have to have your day in court before an eviction would occur. And we can talk more about that in the future and later on as to what that looks like. In addition, we can make an effort to try to mediate with the landlords, because legally they are allowed at this point to increase the rents as much as they would like. We don't have a law that we can fall back on to say that it's unlawful, but we can question the rent increase. We can ask them to justify the rent increase, and we can try to mediate that and see if we can reduce it for you, or at least disperse it into a longer period of time. In addition to that, the Office of Landlord Tenant Affairs provides other services that are not related to rent increase. So if you're having an issue with your landlord and for some reason you want to end your tenancy sooner, that is something that we can provide assistance with. If you are having an issue with your security deposit, if you've already moved out of your rental premises and the landlord hasn't provided your security deposit within 45 days with a justification as to anything that they've withheld, then please reach out to us, because that is unlawful, and we can assist in trying to negotiate something. And if that doesn't work out, we can always refer it to the commission as well, where there is a trial. If there's any violation of the lease on behalf of the landlord, that's a situation that we can provide assistance with as well. Or if, for example, your rent isn't correctly reflected on the ledger, and as a result of that, you're also being charged fees that you shouldn't be, those are all situations that we can provide assistance. And the way that our process to do that is that you file an ALTA complaint. You can email it in to our email address, or you can mail it in. And then afterwards, an investigator is assigned to you. The investigator is a neutral third party. They are not there to advocate for tenants or for landlords. They will investigate the case. They will contact both parties. They will try to mediate. They will schedule a conciliation. And if mediation and agreement doesn't occur, and if there is still a question of law or a question of fact, then it will be referred to the Commission of Landlord Tenant Affairs, where there will be a hearing held, and then that final decision will be made. So please use our services. In addition to filing a complaint, if you're just interested in getting information or finding out about the law or just have general questions and you want answers before contemplating filing a complaint, you can call our office. You call 311, ask for the Office of Landlord Tenant Affairs. More than likely, you'll have to leave your name and your number, and one of our investigators will contact you within 24 to 48 hours. We have a very good callback rate, and our investigators are very well informed and have a number of resources they can provide to you. So if you're not ready to file a complaint or you just want general information, please call us. You can also email us, and we also respond to our emails within 48 hours. Now, it's important to distinguish the difference between the Office of Landlord Tenant Affairs and code enforcement. Many of you may have maintenance issues in your property. If your sole interest is for that maintenance issue to be resolved, then you should not be contacting the Office of Landlord Tenant Affairs. You should be contacting code enforcement. And you can do that also by calling 311. You can do it anonymously if you so choose. A inspector will be assigned and will come out to the premises. They'll let you know in advance on the date and time of the inspection. And then if they see any violations of code, then they will inform the landlord. And depending on the urgency of the matter, how long they will give the landlord to rectify the situation. So if what you have is a maintenance issue, I ask you to please contact code through the 311 process. If you have a maintenance issue, and in addition to that, you would like some kind of relief. So for example, you would like to terminate your lease early, or you would like a reduction of payments of rent because of this inconvenience, then you can file a complaint with our office. We will then forward a copy to code inspection. Code will take care of the maintenance issue, and our investigator will work with your landlord to try to mediate a remedy for you. So that's just kind of a general description of the services that Ulta and Code provides, the difference between the two, how to contact us. And we do encourage to please use us as a resource. In certain situations, mediation or our office may not be ideal. We can also let you know when it would be a good idea to maybe pursue your action in court and provide you reference resources for doing that as well.
I saw in the chat that somebody asked about 2-year leases. If you live in Montgomery County, not Tacoma Park or Rockville City or Gaithersburg City, but in Montgomery County in general, those 3 jurisdictions have their own housing laws. Many of them are consistent with Montgomery County, but not all of them. But if you live in Montgomery County and you are not receiving an annual financial recertification, so if you're on an HOC voucher or you live in a low-income housing tax credit building or some other situation where you are required to provide annual financial certification, other than that, the landlord must include in the renewal notice, as we mentioned before, a 2-year lease option. You don't have to have it, you don't have to take it, but they have to offer a 2-year lease option. They can offer a 1 week, they can offer a month, they can offer 6 months, they can offer a year and a half, whatever they want. They can offer a 10-year lease option if they want, but they must include a 2-year lease option. So if you haven't been receiving a 2-year lease option in your renewal notice, and you don't live in Tacoma Park, Rockville, or Gaithersburg cities, then your renewal notice is likely to be defective or illegal.
Gaithersburg is consistent. Oh, sorry, Gaithersburg's consistent. I was just throwing that in. It's the same.
Well, good to know. Thank you, David. David lives in Gaithersburg, and he's on the Commission for Landlord and Tenant Affairs in Gaithersburg, so he knows. Folks, what other questions and concerns do we see?
That same person asked if there's a requirement to report rent increases to any sort of agency or anything, that landlords do that. And I didn't know if that was a chance to reiterate that. I mean, I think the complaint process, I know that it's helpful, to bring it to your attention that way, but is there a landlord reporting requirement for that sort of thing?
There is not.
But there is an annual rental survey. that DHCA does. I don't know how granular it is. But we'd like to see that. I think having some data apartment by apartment would be very helpful to know what kind of increases we're seeing across the county. Or maybe even a scientifically conducted survey would be helpful. But if you've received that rent increase that's excessive, let us know. What else, folks?
We had another
I
question.
don't,
Oh, go ahead, Pat.
I'm sorry, I don't see on this cash yet someone asking, but I get calls and letters. Everyone I call want to know where they are in the process of receiving money. And I know, Nicole, you working on that. They're working on that really hard. You don't have any pat answers, but they would like to know or have some idea when they may receive some relief from the county. Is there anything you can tell them in terms of when they may get any of their money, or are the applications going smoothly? And
So DHHS, they have their staff working very diligently on processing the applications for COVID rent relief. For those that applied in phase 4, I encourage anybody who's in a situation where a legal complaint has been filed against them in court, that as soon as they have a summons or as soon as they have any proof that a case has been filed against them in court, that they inform DHHS via their email, and they will then prioritize the distribution of the funds for that application. You don't have to wait until you have an actual eviction notice. As soon as you know that you're in court proceedings and you can provide proof of that, I recommend that that you email them immediately. And sometimes you have to wait to receive your summons. Sometimes you can look up your name on Maryland Case Search and you will see that there's been something filed even if you haven't received a summons. And I would encourage people to print that case search and use that to prove to HHS that there is a case that's been filed against you. The county has said that they have funds, that anybody that qualifies for COVID rent relief that applied in phase 4, they're expecting to be able to distribute those funds and grant that money. So just be patient. And as far as you all know, the COVID rent relief portal had closed. It has now reopened. So if you or your family, or if you have friends of people who you think may qualify and that would benefit, I encourage to go to the portal to reapply. The requirements are going to be the same as they were for phase 4. It's just an extension of phase 4. And we do not know how long the portal will be open and extended for. So please share that information and urgently encourage people to apply.
A couple things I want to emphasize about that. There are limits to the COVID rent relief program. First of all, you have to be impacted by COVID. You have to live in Montgomery County and you have to have been impacted by COVID. It is not a rent relief program in general. If you're behind in your rent for reasons that have nothing to do with COVID, this program cannot help you. The federal funds that have come to the state and then to the county are required to be for COVID rent relief only. So you have to be eligible. Unfortunately, it's not something that makes the Renters Alliance happy, but the program is set up to prioritize those who are closest to eviction. If you've received a court summons since you applied, or if you've received a court summons and a judgment against you, and now you've received what's called a red and white notice on your door from the sheriff's office, you need to make sure that the Health and Human Services Department, the COVID rent relief staff are aware of the change in that status. And you can do that if Malek or David, somebody could put that in the chat. You need to communicate to them by their email, which is hss@montgomerycountymd.gov. Let them know that your eviction situation is escalating. They are expected to prioritize. Now, For those of you who may have been rejected for some reason, if you feel that you have been rejected from the program or denied benefits for an unfair reason, or because you didn't submit documents and now you have those documents, we can help you reopen that case and get a caseworker to review your file and your application and see if there was a mistake or see if there's something they can do to reopen it. There are no cases that are closed permanently because something was not submitted. It just means that they're not going to keep looking at it until they get the information. They contact you, ask for the information. If you don't provide the information in a timely way, they've got to move on to somebody else. Now, if you find the information or you realize that you are missing that information and just got it, we'll help you reopen the case. If you have a dispute with your caseworker or there's some confusion, we're also here to help you there. So just let us know, email us at info@rentersalliance.org. What other questions and concerns do we have in the Q&A or the chat, folks?
We've had a couple related to month-to-month leases. One where I think someone actually received a renewal before the May 15th, but didn't, but I think maybe possibly a deficient renewal they meant, and then didn't sign, but is now month-to-month. We had another question about how long can they just keep you month-to-month? And I know we already mentioned that rent can only be increased once a year. That seems relevant, but I don't know if there's any other information we could give about that scenario.
Nicole, you want to take that?
Sure. So if you received a rent increase notice prior to, what was the date, Matt?
May 15th.
Thank you. Prior to May 15th. And if it was on an unlawful amount, please contact us immediately and we will review that with you and we will contact the landlord on your behalf.
Prior to May 15th, since February 5th, I want to say, until May 15th, the allowable rent increases in Montgomery County were 0.4%. If your increase was above 0.4%, then your renewal notice was defective. Again, contact the Office of Landlord and Tenant Affairs, ulta.intake@montgomerycountymd.gov. We put it in the chat. You can also contact us at info@rentersalliance.org. Let us know. These are fixable problems. In fact, there's nothing I like better in a complaint process than to see something that's obviously wrong. And if you have a renewal notice that's illegal or defective, it's easy to fix. They can't do that. So, help us help you. What else, David? Or Malek or Pat?
Yeah. Oh.
Pat, you're on mute.
Yeah.
There we go.
I'm trying to understand. A lot of them are just stating facts. They're not asking real questions.
Well, then
We're
let's address
trying
some
to
of
get
the
through
statements.
it.
We're just reading.
Okay, Carolyn, did you understand what Nicole was saying about the housing stabilization that you were having, that they said that you were told that was different? That it was just explained. I hope you got what Matt as well as Nicole was saying.
Well, let's read what she said. She says, I wanted to get some assistance as a tenant and renter about housing regulations and guidelines, including violations and unsafe and unhealthy conditions, and how I'm able to report those and to whom. I have attended these meetings regularly and have never had an issue with participating in chat. Good. So let us know if what we've outlined before did not address that. Hopefully, what Nicole Katravanos outlined about the differences between code enforcement and the Office of Landlord and Tenant Affairs and how to contact their offices and make a complaint. So if you have any other questions about that, let us know. Anything else, David?
Yeah, just a housekeeping thing. I don't believe we have dropped the code link in the chat yet, so I will get to that. And then there was another question about if there's a required to provide 90 days notice of intent to vacate for a tenant. So I didn't know if you all wanted to just review the notice requirements for the landlord and the tenant.
So the I highly recommend that you look at the lease. Sometimes the lease will say what the requirement is for the tenant if they're going to vacate. If your lease term is going to end at a certain date, and if there is no clause in the lease that requires you to notify the landlord if you're going to be renewing or not, then you technically don't have to provide a notice. But if there's a requirement in the lease, then you have to follow the requirement on the lease of how many days you need to notify the landlord if you're going to vacate the property at the end of the renewal date, at the end of the lease term.
But it's my understanding, Nicole, also that the lease cannot require it be longer than what the law is. And the law is 60 days, I
60
believe.
days. Yeah.
So they can't say you have to give us 2 years notice. They can't say you have to give me 6 months notice. They can't require, no. If they say they will only require 30 days notice, then as Nicole points out, then the lease benefits you even more. So the law is not going to intercede there. But I believe that they can't say longer. If the landlord has to give you 60 days notice to vacate, then the tenant also has the same period of time to
It
give
can't be
notice.
longer. That's correct.
Right. Now, is that always true with month to month, which can be shorter?
No, month to month is just 30 days.
It's 30 days. So if you're longer than month to month, it's 60 days. If you're a month to month tenant, it's 30 days. Now, in a 30-day situation, could a lease say, yeah, but I want 60 days?
The landlord?
Yeah.
No.
So it's 30 days in the law, no matter what.
Yeah.
Okay. I hope that answers somebody's question.
And somebody had a question about a less than 90-day rent increase notice. That's not lawful. So please email us with a copy of that rent increase notice.
This comes from Marcia. Do you ever refute those who oppose rent increase stabilization by asking, what would you do if you are homeowner and every year you would have a mortgage increase of 10%? I'll tell you, we did have that happen. And you know what we had? We had a national foreclosure crisis. So renters have this happen every year. And we think that, you know, the Renters Alliance takes a very reasonable approach here. The landlords will rue the day we go away and some of our allies step in to advocate because they wanted things much tougher. We want a balance. We understand that landlords are in the business to make a little money, but they are in a business that's not the same thing as beer and cigarettes and fancy sneakers. Housing is critically important to the health, welfare, and prosperity of our communities. And so if you want to enter into this business, you can make a little money, but it has to be reasonable. We also understand that you need to keep up with your overhead and your expenses. Okay. So that's why there's a CPI, a consumer price index that looks at specifically those expenses that landlords have, heating, maintenance, and staffing, and so on. And they come up with what the inflation rate is. And they say this is about what it is in a percentage to keep up with the rate of inflation. One expects a landlord, when they charge rent initially, if they have any kind of marbles upstairs at all, that the rent will be their overhead to start with, and then a measure of profit. And if you decide to move into that apartment and pay whatever you're paying, $1,500 or $1,800 or $2,500, a good chunk of that should be for profit. And we have no problem with the landlord wanting to maintain that measure of profit consistently. We have a major problem with landlords who say, you know what, I can get somebody to pay 50% more than you, so goodbye. That's a problem. That's if you're selling beer, cigarettes, and sneakers, not if you're in the housing business. That's what we would consider irresponsible. The Renters Alliance, I should point out before Nicole rolls her eyes, we are an independent nonprofit, and we can say what we want. The county has certain regulations and that they have to abide by and rules. And so I'm speaking my mind on behalf of the Renters Alliance, not necessarily on the side of the county.
Thank you, Matt. Something that I just wanted to reiterate for those individuals that are facing challenges in paying their rent. There are two sources of funds that the department has to provide assistance to tenants. One is through the COVID rent relief program, and the other is through housing stabilization. So if you do not qualify for COVID rent relief, or if you've tapped out of the amount of money you can receive assistance from there, or your application has been rejected, you can always ask the department for assistance through its housing stabilization program. And you can do that by calling 311 and asking specifically for the housing stabilization office or program, or you can go in person. They have 3 offices. I don't have the office addresses off the top of my mind, but you can look it up online and you can go and ask for assistance, and they can provide rent assistance. They can provide security deposit assistance for relocation. They can provide assistance with utilities as well. So I just wanted to clarify that those are 2 different services and 2 different sources of funds that the county has to support tenants that are having difficulty paying their rent, or that need to transition to another housing and are having difficulty with specific payments to transition to new housing.
I want to address a quick confusion somebody raised in the chat. When we say COVID rent relief and that you've been impacted by COVID, you may have had COVID, but if your income has not changed because of COVID, then you haven't been impacted by it. So the issue is you can't pay your rent because you've gotten COVID. Well, if you're out of work because of COVID, or you've lost your job because of COVID, or your hours were reduced because of COVID, your company not making money, so they laid everybody off or reduced your hours, that's the impact we're talking about. If you get COVID and you're on sick leave and you're still getting paid, then there should be no reason why you can't continue to pay your rent. And so that's not what the COVID program was set up to support. So just keep that in mind. It's not getting COVID, it's being economically impacted by COVID.
And you have to demonstrate that you have been unable to pay your rent for 2 months in order to qualify.
And that too. What else, folks?
Matt, this, I guess Kenny has a question. At the end of it, it says also, how can future rent stabilization laws prevent notices of non-renewal? And I just want to say that, like all laws, they have to be passed some kind of way. Hopefully we can get people or congressmen, councilmen, and the legislation that are for rent stabilizations. So that's why it's so important to vote for someone who can help the renters.
Well, I could
So
not
that's
agree
the-
more, and
that's
hopefully
the-
everybody did vote. And if you didn't, you'll have another chance in November, and we will start hitting that again in the fall. Was the question related to non-renewals, those who have not received a renewal? Was that the issue? Somebody, David? Anybody?
Yeah, there were actually 2, and they were very, very similar, and
Yeah.
both kind of like we were worried about rent increases, but also even when the cap was in place, we were worried we were going to get a non-renewal, and some of our neighbors did. And so I mentioned, Renters United Maryland, the coalition that was pushing for a good cause eviction law, just cause eviction law to pass. That didn't pass though, unfortunately. So we don't see that in any jurisdictions right now, that protection. But yeah, there were a couple about that.
Well, so just so people understand, just cause protection means that a landlord would have to automatically renew your lease year to year or month to month or whatever, absent a good reason, stated reason not to, a stated reason acceptable in the law. So obviously any justifiable reason to evict somebody would be one of those reasons, but there are also other reasons, like a small landlord has decided to take that rental unit off the market entirely, or they intend to move in a family member, or any kind of landlord, small or large, has decided to do substantial renovations of the property that would make the apartments uninhabitable. So those justifiable reasons might come into play as well. But right now, there is no such protection. So with 60 days notice, a landlord could say, we're not renewing your lease. And if a tenant stays 1 day longer than the end of that lease, they're what's known as tenant holding over. And the landlord can take that tenant to court for tenant holding over. And there is little or no defense because all the landlord has to show is that they gave proper notice. Now, if you could prove that the reason why they were doing that was for some illegal retaliatory reason, whether from discrimination or from forming a tenants association or for complaining about building conditions or pursuing your rights or promised or required services, then you might have a case. But it's extremely difficult because you'd have to have really solid proof. And the landlord does not have to state the reason why they're not renewing, which makes it very difficult to get them to admit an illegal motive. So very difficult. Nicole, you want to have any assessment of that?
Just that if you're in a situation where you have filed a rent escrow case in court, and then soon afterwards you received a notice of non-renewal, that would be an ideal type of situation where you could provide the defense of a retaliatory eviction.
Right. And you can always try. And sometimes, that's a good example. You've recently tried to form a tenants association, and right afterwards, you got a notice that they want you out. Or they want you and two other people out who tried to form the tenants association. A little bit of Judge Judy common sense here. If you think you've got a case, then let us know and we'll try to help. We can guide you. And if it's a solid case, we may even refer you to the Office of Landlord and Tenant Affairs, or maybe even to a lawyer. So, that is something, but it is a very difficult situation for many renters if we don't have just cause eviction protection, which the Renters Alliance has been pushing for a decade. And we are the leading co-founder of Renters United Maryland, and our coalition has also been pushing it. And one of our board members, Delegate Janelle Wilkins, is the champion for that in the state assembly. So we hopefully will have another go at it this year. And anybody who's interested in supporting that effort, please contact us and we'll use you. What else? How long can a landlord keep you on month to month?
No, please get that to Mama. And no,
I thought that came up before.
It's
It's because there's another one right before it while you're on that, is if you do not get a rental renewal lease, just no communication, how long can you stay? And, we are month to month, and my understanding is it's indefinite. I thought kind of in our situation here, but I don't know if there's a limit there.
It is indefinite, but if they don't give you a rent, they can't give you a rent increase.
Once a year still, right? Is that?
No, but the rent increase would be considered a renewal. Is that correct, Nicole?
A 90-day rent increase notice?
No, any rent increase. If you're on month to month and they say you're on month to month, but your rent just increased, wouldn't the increase constitute a renewal?
I'm not sure about that. I mean, essentially, it is, since you have to give a 90-day notice, there's an assumption that the tenancy will continue for the next 90 days. And at the end of the day, either the tenant or the landlord can terminate that tenancy prior to that. So if you're on a month to month and a landlord gives you a 90-day renewal notice, you can still as a tenant end your tenancy prior to that, as long as you provide 30 days notice.
Right. I'm just thinking about if you got a rent increase notice on a month to month, that it constitutes a renewal and therefore also has to include a 2-year lease option and all of the other information. Otherwise, if they just say, we're not going to say anything, we just want you to give us an increase, seems a little slippery. Seems like they would be obligated to the requirements of a renewal.
I'd have to look into that. I don't feel comfortable saying 100% yes, so I can look into that and then we can.
Yeah. Anyway, that's my position, but I'm not a lawyer.
Yeah.
So, but I think that we've seen this before a little bit, and I think that's the way it panned out. Anyway, food for thought, and we will get back to folks on that because I think that's important. We don't like it if a property manager or landlord is trying to circumvent what is an intended process to notify tenants according to the law. And likewise, if they don't give you a renewal notice or don't give you an increased notice, your month to month doesn't have a increase. And they can only make a rental increase once in a 12-month period, as we said before. What else, folks?
So if you could just remind people about what the entrance into the apartment is about, 24 hours notice unless there's an emergency situation.
Nicole?
So the landlord does have the right to access the property so long as they provide proper notice, which it doesn't, I think it's 48 hours. Maybe it's 24, I can double check that. And the request to enter the property needs to be during reasonable time period. So it can't be at midnight or at 5 o'clock in the morning. If there's a situation where there's an immediate emergency situation in the property, like some flooding, for example, then the landlord can have access to the property by notifying as soon as possible, or a shorter period of time. But the tenant cannot block the landlord from entering the property if they provide proper notice and if they're entering the property during a reasonable time, so long as it doesn't result in harassment. So if you're in a situation where your tenant is constantly trying to enter the property and they don't really have a valid reason for doing it other than to feel uncomfortable, then that can equate to harassment and you can request a peace order in district court.
Thank you.
Some other considerations there too. Back to the issue of being reasonable. So say you receive on Friday that they're coming in on Monday and you work and you don't want anybody in your apartment unless you're home. It is perfectly reasonable for you to say, hey, look, this isn't enough notice and I want to schedule a time that's more convenient for both parties. Now it depends on for what. If it's something urgent that the landlord needs to do, but is not quite an emergency, then they might have a case. But if they decided on Wednesday that they're going to call in the exterminator and it's coming on Monday, that's not really giving you enough time, especially if maybe you have health issues and want to, get the apartment ready or any other reason. So you could certainly negotiate that with your landlord first, your property manager first. And if you find them to be unreasonable and you have a valid claim to reschedule and they won't do it, then you should contact the Office of Landlord and Tenant Affairs or us. We certainly can help in that regard. Another thing is that unless it's an emergency, when they're going to just come in because there's a flood or a fire or some other serious immediate condition, if they knock on your door and they give you, either they didn't give you 24 hours notice, or even if they did, it is still your private property and no one can push into your apartment. That would be trespassing and you could call the police. You could also block the door and say, you're not coming in. Now, we advise that if they've given you proper notice and you have not said, I don't want you to come in on that day and you don't have a dispute, and they come in and they're trying to come in lawfully, and you say, no one ever comes into my apartment to fix anything, and that's the way, then you may be in violation of your lease, and then they could possibly sue you for breach of lease for failing to abide by the rules of entry when they're acting in good faith. So, I'm not suggesting that you should, say nobody can come into your apartment if they're acting in good faith. But if something's happening too fast, you're not sure who he is, you don't recognize the maintenance person, or some other issue where you're not comfortable with somebody coming into your house and you're acting in good faith, it's your private property. So unless it's an emergency, they do have to knock and say, is it coming in? And you have to let them in.
And just to clarify for the timeframes, if it's non-emergency, it has to be 24 hours. If they're requesting access to the property as a result of a code enforcement issue, then it's 72 hours.
Right. What else, folks?
Matt, one of the viewers wrote earlier, and I wrote back, they wanted to know if there was a maximum amount that a landlord could increase the rent. And I wrote back saying that I didn't think it was a maximum amount. Could you just speak to that, Nicole or Matt? I mean, I don't
Go
want
ahead,
to tell
Nicole.
anyone.
Swat that irritating piece of information that we have to address.
But that's what we've been addressing nonstop, is at this point, the landlords have free reign to
Yeah,
increase the rent.
I
as
just
much as-
wanted everyone to hear it.
That is the situation right now in Montgomery County. There is no rent cap. There is no restriction as to how much they can increase the rent. We're encouraging all tenants who have received what they consider to be an unreasonable rent increase to contact our office, ideally to send us an email with a copy of that rent increase notice so that we can document it, one, and two, so we can see if that notice is valid. If it's not valid, if it doesn't satisfy all the requirements by law, then we can address that directly with the landlord and we can make them reissue you a new rent increase notice, which at a minimum will buy you 3 more months. And we can provide assistance in trying to negotiate something with your landlord, but since we don't have a law to fall back on, there's no guarantees of having a fruitful result.
Thank you.
Let me quickly introduce our vice chair, Chris Perry, who's the vice chair of our board. Chris, you've got your yellow hand up. Do you have a question or concern?
Yeah, we talked earlier in the evening about finding out or demonstrating or documenting that you have that you've got a court date for an eviction proceeding, and you can, if you need to, go to the Maryland case search webpage and see if you can find your court case there. I've put the link on the chat.
Okay. Nicole, who is a lawyer and practiced as a lawyer prior to becoming the manager, is that the best approach for a tenant who wants to get information about a case filed against them to look case search, or would you recommend that they contact the clerk? What would you recommend?
So it depends on the type of case it is. If it's a tenant holding over case, which is a situation where a landlord had said they don't want to renew your case, and they don't want to renew your lease and they filed against you, or if it's a breach of lease case, then using Maryland case search is an ideal way to find out if there's been a case filed against you. Failure to pay rent cases are a little bit more complex. They don't always get uploaded immediately into the system. So you can always call the clerk at the district court and ask them. They tend to have a separate manual list of cases that have been filed, and you may be able to find out sooner if they filed a complaint against you for a failure to pay rent case.
Any tenant who's going to court should have received a court summons. And on that summons will tell you the date and time of your court case. Sometimes you can't read it, so it's not printed very well. So you can call the clerk and say, and give them the information, find out more specific information. By the way, if we haven't said it 5 times, let me say it at least once. Always go to court. Don't avoid a court case. If you have any kind of defense at all, if you don't show up, it doesn't matter, you lose. Since we're talking about different types of cases, let's be clear. Nicole, you're probably better at it than I am. What are the 3 most common ways to be evicted, and what are the differences?
Sure. So we'll start with the failure to pay rent. That's when a tenant has not paid rent. What happens in that situation? A landlord has an obligation to first provide the tenant a document that's called a summary ejectment for failure to pay rent document. And in that document, they will list what months they are filing for. And they have to provide it to you after either they have to post it on your door. If you've conceded to electronically receiving it, you can receive it electronically or send it by certified mail. I believe those are the requirements. After they provided that document to tenants, they have to wait 10 days. If the rent hasn't been paid during those days in full for the time period listed on the form, then the landlord can file a failure to pay rent action against the tenant in court. Then the court will provide a summons with the date of the hearing. A hearing will be held. The tenant can pay at the day of the hearing or before the hearing. If that happens, then the case will be dismissed. Even if you pay, and if the agent of the landlord tells you, don't worry about it, we'll dismiss the case, you shouldn't go to court, you should definitely go to court, because I have seen situations in the courtroom where a landlord didn't dismiss a case and a tenant was there with proof that they paid. And if they hadn't been there, and if they had just taken the word of the agent, there could have been a judgment entered against them, which can provide, it will end up being difficult in the future for renting. So even if you paid your landlord, show up to the hearing and show up with proof of payment. And then the case will be dismissed. If you go to court and if you haven't paid your rent, then after that, the landlord has to file what's called a warrant of restitution. And basically, that is a document that goes to the sheriff, and it tells the sheriff and notifies the sheriff to start the eviction process. At that point, the landlord has to contact the sheriff, they schedule an eviction date, and then typically, it's not required, a red and white notice will be posted on the tenant's door, notifying on the date that the eviction will occur. The tenant has up until the date of the eviction to pay the amount of rent in the judgment for failure to pay rent. So let's say the landlord filed a failure to pay rent judgment from January to March, and your hearing is held in June, and the eviction is scheduled in July. Even if you haven't paid rent up until July, you only have to come up with the rent from January, February, and March to avoid the eviction. So the amount that's on the judgment is the amount that you have to pay to avoid eviction. So you can pay to stay. You don't have to pay up until the entire amount of rent that you haven't, that you may be delinquent on. That is a big way that landlords file for eviction. It's important to note that if a landlord has filed a failure to pay rent more than 3 times, on the 4th time that they file a failure to pay rent, they can request what's called an absolute judgment. And that means that you lose that right as a tenant to pay to stay. So it's very important that you do everything in your power to prevent a case being filed against you if you can, because by the 4th time they can get an absolute judgment and you can't pay to stay even if you're in COVID rent relief. Another common way that landlords can evict tenants is through tenant holding over. So basically, if you're on a month-to-month or if your lease is about to expire, the landlord can provide a notice saying that they're not going to renew your lease. And at that point, they'll put a date on the notice saying when you have to move out. And if you do not move out by that date, they can file a tenant holding over case against you in court. And the only thing they need to show on the date of the hearing is that they own the property, that they provided you that notice, and that you did not move out. I have noticed when I was working in court that judges don't always look to see if the notice was provided in a timely manner or not, because the hearing date will sometimes not be scheduled until 6 months after. So they feel that the notice, while the notice may not have been timely, the tenant has had proper notification because enough time has gone by and they will move forward with the tenant holding over case. And once that judgment is entered, again, the landlord has to file a warrant of restitution and the sheriff schedules an eviction date. And if you think that you might be at risk of having an eviction date scheduled, you can always contact the sheriff's office to ask if a date has been scheduled, if you haven't received your red and white and you just want to make sure. So you can call the sheriff's office and ask them. Another way of another mechanism landlords use to evict tenants is through a breach of lease. So those are typically in situations where the tenant has breached one of the clauses in the lease. These cases can be a little bit more difficult to prove. It requires for the landlord to provide more evidence. If unsafe, if the tenant has been acting in a way that's not safe or that's jeopardizing other tenants in the building, that could be a reason for breach of lease. If the lease doesn't allow for pets and the tenant has a pet in the property, that could be a reason for a breach of lease as well. And that is a little bit more of a complex situation because you have to provide proof in court that the lease was breached. And we usually recommend for breach of lease cases that tenants find representation. And those are the three main ways that landlords, the mechanisms, the legal mechanisms landlord used to evict tenants.
The breach of lease one is basically you're not abiding by the rules of the apartment community. You're not abiding by the rules laid out in the lease or the rules in the apartment community. But one thing about breach of lease is that, except for severe cases, as Nicole points out, where you're a danger to others, or you're committing crimes that are clearly disruptive or dangerous to the community, in common breach of lease cases, like you have a dog when you're not supposed to have a dog in the apartment, there's a cure. By the time you get to court, you don't have the dog anymore. There's really no reason to pursue the eviction. Now, you might have to prove that you don't have the dog anymore, however you do that. But there are ways to fix a breach of lease case as well. So we can help you, advise you on that, and if necessary, we'll either help you fix it or advise you to get an attorney or some other remedy. So there's a large range in breach of lease cases, from the very severe to common disagreements that can be resolved. So,
And it should be noted that fortunately, I shouldn't say put my position on that, but tenants cannot file breach of lease cases against landlords. So only landlords can file breach of lease cases against tenants as a form of eviction. So if your tenant is breaching your lease, one remedy potentially could be a rent escrow case, depending on the situation.
I mean,
And
if the
then
landlord is breaching the lease.
Thank you. Yes, if
Yeah.
the landlord has breached the lease. Or if you don't qualify for that, if you don't want to go through court, then we recommend that you go through our office and you file a complaint as to how your landlord has breached their lease or is not abiding by the obligations under the lease.
Okay. Folks, David, Malek, Pat, anybody see any other questions or concerns that we have not gotten to? What are our rights as to posting in residential portals about building-wide issues? I posted to see if any neighbors were struggling with mice, and my comment was blocked from being posted. Interesting. Am I supposed to hang posters on the wall? Yeah. Yes, and yes. The Renters Alliance, I'm proud to say, passed legislation with then County Council member Mark Elrich, who's now the county executive, and one of the provisions strengthen tenants' rights to organize, and that includes distributing information about tenant issues in the building and holding tenants meetings once a month at no charge in community facilities. As far as I know, Nicole, if there is an amenity in the building that includes communicating with your neighbors, I don't know if the landlord has the right to block special messages that have to do with tenant organizing. What's your thinking on that?
My gut instinct is no. I can't tell you right now a law that would say that, but my gut instinct is no. And if that's happening, you should definitely contact Renters Alliance or contact us and let us know.
Yeah, that doesn't sound kosher to me. I think that, especially if it's done in good faith. Now, bear in mind, if it's malicious or not true, or in some way inflammatory and not done in good faith, they might be within their rights to say, hey, look, you can't say that kind of stuff in our community portal. It's meant to be civil and constructive and help build community and all the things that we support. But if you're saying, hey, look, the laundry facilities have been broken for 3 weeks and we're having problems, and is anybody else having these problems? I think that you'd be perfectly within your rights to do that. And if they blocked you from saying that, I think that we would have a justifiable complaint to pursue. So just keep that in mind. I hope that answers that question. How long after renewing a lease does a landlord have to provide a complete copy of the lease to the tenant? I've been waiting for months. My sense is they have to write it immediately. What do you think, Nicole?
I mean, it should be within a reasonable time. Over a month is too long. So please contact us. We can reach out to the landlord to make sure you have a copy of your lease.
Now, when you first move in, a tenant is entitled to receive a copy of the lease to review before they sign it. How many days is that, Nicole?
How many days do they have to review it? I don't know.
I believe it's 2 or 3 days. I'm not sure. But you're allowed to receive an advance copy of the lease to take with you to review before you sign it. And I believe you're allowed 2 days after you sign the lease to then go back and say, I changed my mind. I believe that's in the law of 1915. Last I was reading it the other day, but I can't trust my memory. But I believe that is required in the law. So if you feel like you weren't given a copy of your lease and you want one and they're not giving you one, I think you need to contact us or the Office of Landlord and Tenant Affairs or both and get a copy. I think it would be a big mistake by any tenant not to have a hard copy of your lease in your records. Property management changes over time, landlords change over time, and the basic agreements in your lease should be the basis of your landlord-tenant relationship. And if anything changes, they have to do so in writing. So you need to have a copy. If you don't have a copy, they could say that they never agreed to that years ago, and you'll have no proof that they did. So keep that in mind.
So
What else we got?
We're running into, this is not like with Runners Alliance. I know David and I are both running into situations where property management is not offering leases.
What do you mean?
So they have like their lease expires and they're not offering renewals. They just want to go month to month. And I'm running into this with senior properties specific. I think David has a couple too, so.
A couple in the senior world?
I have seniors, but I think David ran into that with a couple of his properties as well. Right? Didn't you?
Just just letting it go month to month.
Yeah.
Yeah, I'm seeing a lot more of that. And I'm because there was a kind of a wave of non-renewals we were seeing, but luckily I'm not hearing too many calls about those as much, knock on wood, but then there is this kind of newer thing I'm seeing a lot more now, which I happen to be in that situation where they're just not really responding about renewing, but that they're not trying to terminate the tenancy. Yeah. And I think we have got a question that sounds like they might be having it at Arrive Wheaton in the chat there too, but yeah.
Right. A number of landlords have determined strategically, because of the rent cap laws, that it is better to go month to month and wait out these laws. And because of the specter of this new law possibly passing yesterday and it not passing, but they weren't sure. So a lot of them were waiting out by allowing tenants to go month to month, which would then allow them to raise rents when these laws expired. And if they weren't sure, they just have you stay on month to month. So it gave them more flexibility to just wait out any rent stabilization law until such time as they could provide you with a renewal with an increased rate that they wanted to give you. So that was one of the reasons behind all of these month to month leases. The other was because so many tenants, particularly working class tenants who were impacted by COVID, found themselves unable to pay rent, and they weren't sure whether they would recover or not. They wanted to make it easier for them to evict those tenants by having them on month to month. And on the month to month lease, they could give you every month a 60-day notice to vacate for tenant holding over, which is more flexible than if you had a 2-year lease. They can't get you for tenant holding over, and with the eviction prevention laws that had been in place in the previous years, they couldn't evict you for failure to pay rent during that COVID period. So they were much more restricted. So going month to month allowed many landlords to have more flexibility in pursuing eviction if they so choose.
Just wanted to throw in, we had a question about, can you request a copy of your tenant records in your file? I did want to just use that as a chance to mention, you can get a copy of your ledger, right? Is that true that you're supposed to be able, that's something else you're supposed to, I think, be able to request a copy of?
Nicole?
Yes, you should be able to have access to your ledger.
And of course, it's supposed to be absolutely accurate and up to date.
And these are the types of cases that the Office of Landlord Tenant Affairs can provide assistance with. If the landlord is not being responsive to you with your request to receive a copy of your lease or receive a copy of your ledger, then you can contact us and it won't take long for us to be able to get that information for you. It's just a matter of contacting them on behalf of the office with a letter, and then you should be able to receive it shortly.
On the issue of changing the terms of the lease, the landlord cannot do that at any time that they want to. They can do that in between the terms of the lease. Now, they can change the terms of the lease if you want to change the terms of the lease and you mutually agree, which should be in writing.
Mhm.
But absent that, you know, if you're in a 2-bedroom apartment and they say we're going to move you to a 1-bedroom apartment, they can't do that in the middle of your lease. Can't do it during the term of the lease. But because there's no just cause eviction protection, which requires the existing lease to renew automatically with the same terms, with the exception of hopefully a reasonable rent increase. At the end of a lease term, the entire lease can be rewritten and renegotiated. They could say, we're not keeping you. They could say, the only apartment we have available is upstairs and it's a 1-bedroom instead of a 2-bedroom. They could say, we're no longer going to have tennis courts. They could say, at the end of your lease, and at the end of all the leases in this building, we're not going to allow pets anymore, or we are going to allow pets, or we're not going to be a smoking building anymore, or we are going to be a smoking building. Whatever, they can change the terms of the lease after all leases that have contractual agreements expire, but not before.
As long as whatever changes are lawful. So they can't make you sign something or agree to something that is unlawful or contradicts the law.
Right. What's a good example that we've seen? I've seen one with in a senior building that said all the seniors have to clean out the gutters of the building. No. Not going to happen. This one comes up all the time, Nicole. Can a landlord fine you?
Fine you?
Yeah, so we have, you know, the landlord says if we're coming up to change the filters in your air conditioners, if we find any plants on top of the air conditioner when the maintenance guy comes in, we're going to fine you $25 for each plant.
No.
No. Can they fine you and say, I lost my key, so in order to get your key replaced, we're going to charge you $200?
If the tenant lost their key? Is that a part of the lease?
Well, let's say it is part of the lease. As far as I know,
Mhm.
they cannot make an arbitrary charge for something that, if it doesn't cost them $200.
Yeah, the fee needs to be justified. So for example, some properties have swabs to enter the property, and maybe every household is provided 2 swabs. And if you lose one, they can charge you whatever the cost is for replacing it. And if you think that whatever it is they're charging you is too high and they're just basically benefiting off of you, then you can ask for them to justify that with an invoice. And that's something that the Office of Landlord Tenant Affairs regularly does. Whenever there's random fees that are being billed to the tenants, then we always ask the landlords to show justification and show invoices to reflect that that is in fact an expense that they have incurred.
We saw another one in a senior building, which I love. If you're caught sleeping in one of the community chairs, you'll be charged $20.
That's
No,
terrible.
we saw another one where in another senior building where people feeding the animals, i.e. the birds, if we find that you put bird seed out or cherries or pieces of bread, we're going to fine you $50. Now, something to keep in mind. They consider it littering. Say you've left all your stuff out there and you've thrown a bunch of bread out there and it's littered the property. And they have to call the property manager out there to clean it up. And it takes an hour of his time. They may be justified in charging you whatever an hour's pay is for the maintenance man. If you lose your key at 4 o'clock in the morning and there's no 24-hour concierge, and they have to call in the building maintenance guy to come in and do it, they could say, look, if ever that happens, we're gonna have to pay the guy at least 2 or 3 hours. Because he's got to get up, he's got to drive in, he's got to do it, and and we have to pay him. And we pay him, $75 an hour, and that's what it's going to cost if you get locked out of your apartment at 4 o'clock in the morning and need to get the maintenance people to come in. But if they have 24-hour concierge and they can hand you the key and you go up and let yourself in and come back and give them the key, and they said, we're fining you $50 for us having to give you a key for you losing your thing, that they can't do.
And
Anything
tenants
else?
obviously have an obligation to maintain the property clean, to keep all the plumbing fixtures clean, to not cause any damage to the property, etc.
Caroline says, I don't think it's justifiable to charge for use of the balcony, though, is it? What balcony? Your balcony? Is there a meter? Maybe a coin drop when you go out onto your own balcony?
Well, I got a notice that like the ones you're talking about related to our back. They were going to say the charge is $200 if they find a grill or a cooler or certain kids' toys out there. And but I think you all have mentioned that you want to go back to your lease in that situation, right? And definitely see what's in there. But yeah, I don't know if that's what they're talking about.
Nicole chime in, but I would think that first of all, your lease probably says that you have to keep your balcony clear of whatever, and it can't be cluttered or it can't be, make the outside of the building look junky.
Right.
Okay, so that's one thing. And if you put stuff out there that they consider junky, then they can make a case. And if it is in fact junky, they could say that you're breaching the lease. Either clean it up or we're going to ask you to leave. But as far as fining you goes, that seems a little out of line. Nicole, what do you think?
I agree.
See, make it easy for Nicole. Yeah, what else we got? Yeah, we'd have to see. A chair is a chair to one person, to another person, it's a lounge with a cooler on it. I don't know.
What is the landlord's responsibility for mold detection and treatment?
If you have a mold issue or you believe you have a mold issue, you should contact code enforcement. If the mold is visible, code enforcement can address it. If it's not visible, code enforcement can't always address it. But if you've done testing and if you think it's affecting your health or you have proof of it, then I encourage you to file a rent escrow account immediately, a rent escrow case immediately with district court.
Yeah, mold is a serious problem, but you can't expect the landlord to have ESP. If you have mold in your apartment, you need to communicate to the property management or the landlord that there's a problem. It'd be good to know the source of the problem. In the summer, you're going to have a lot more moisture. When you have air conditioning on and so on, you have moisture, you might have to do your own effort to try to keep some of that mold down. If it's coming through the wall, because you think the pipes are leaking upstairs or on the side, and it's become a chronic problem, then other types of remediation may be required by the landlord. And if they're not willing to remediate, you need to call code by dialing 311 and making a complaint. Mold can be a serious health problem for some people. All right,
And it's
we're winding
important that
down
you
here.
document your communications with your landlord. So when you notify that your landlord, notify them via email or via text, so you have documentation of that notification, and then obviously give them access to the property so that they can, make the assessments that are necessary as well.
On the cable question, State Delegate Al Carr tried to pass last year legislation that would have required multi-housing communities, would have made it illegal for them to have a single source contract on cable. And unfortunately, that did not pass. And so what we are seeing is that some apartment buildings will have a contract with one company, and they will exclude any other access to other cable sources. So right now, that's a battle because we think many renters are paying more than they should because there's a monopoly in the building. So we're working on it, but yeah, I think that they can say you can only do Verizon, or you can only do Xfinity, or you can only do whatever. That's the way it is right now. What else, folks? We seeing anything? We're in our last few minutes here.
Good.
If it looks like we've answered everybody's questions best we can, then let me say a couple things. Overview, a reminder. You can't let things happen to you. You have to be an active participant in maintaining your apartment and getting your rights enforced and getting promised or required services. To those of you who've lived in your apartments for a long time and just love the relationship you have with your property manager, well, good for you, or your landlord, good for you. But remember, you are in a business relationship with your property manager and your landlord. Handshake agreements, you can do it, but it's a risk. You should always put things in writing, especially if it comes to important things like your rent or any change in the provisions in your lease or move out dates, anything like that, that's serious business. Remember, sometimes the property manager might be nice, but their corporate backing insists on certain outcomes, and they may contradict what you were told. So make sure whatever you're doing with your property management or landlord is in writing wherever possible. Also, acting in good faith, you have an issue, please bring it up with your property manager or landlord first. It's not fair to say, I saw a mouse and I'm calling the county. Well, you need to contact your property management and landlord and say, hey, look, looks like I got some mice. You need to do your part to give them an opportunity to remediate the situation and to work with them in good faith. And believe me, there's no one more experienced in knowing when landlords are not operating in good faith. So, but we want to be able to say that the tenant operated in good faith first and exhausted every reasonable avenue to resolve a situation before we escalate it to the powers that be. As much as Nicole Katravanos' operation is willing to help, we don't want to burden them unnecessarily until it gets more serious. So keep that in mind. Renting can be depressing, somebody said, but it can also be a good time. We have a good time in my apartment all the time. So it doesn't always have to be that way. My landlord has tried to sue me in the past and will never do that again, I promise you. So, this is a business relationship, but I enjoy my home and I hope all of you are enjoying yours and understand that the Renters Alliance is here to advocate for our rights and to expand those rights to protect affordable, quality rental housing. Let us know if you need our assistance. Nicole Katravanos, our new and very informed and capable manager of the Office of Landlord and Tenant Affairs, we thank you. My staff and Chris Perry, our resident Renters Alliance Vice Chair of our board, thank you for participating. And thanks to all of you. But I think with that, we'll say good night.